This is called, in the American tradition, a race to the bottom. And this is the risk that Europe faces. All member states decided to allow €1 or 1 cent companies. This is a good principle, I understand it, because it's the consequence of the development of the European Court of Justice case law. But it leads also to another phenomenon of race to the bottom.
This is actually a change of paradigm.
And as I was talking about censures, everyone knows that censures has had a tremendous effect, a spontaneous effect on the legislation of many member states.
How do you see this shifting, like you said earlier, as an evolution in the future?
Well, you asked me to tackle the most bowling issue of European company law.
Bună ziua, dragi urmăritori, și bine ați venit la cel de-al 3-lea episod al Business Law Talks. Acest podcast care este organizat de către Facultatea de Drept din cadrul Academiei Studii Economice din București și Centrul nostru de studii Drept europene a afacerilor. Astăzi avem un invitat special din Italia, așa că, din nou, limba de conversație va fi engleza. Welcome, dear followers, at the new edition, the third one of our podcast, Business Law Talks, a podcast which is a project of both Faculty of Law within the Bucharest University of Economic Studies and the Center of European Business Law Studies, backed up by our partner, the Romanian Society of Business Law. We have special guests, as we used our followers for the first editions, now from Italy, Professor Nicola de Luca. He's a distinguished figure in European business law, renowned for both his academic career and his practice. He graduated from Luis Guido Carli University in Rome in 1998 with cum laude. And he is holding a PhD since 2004. Nicola is a professor of company law at the University of Campania Luigi Vanvitelli, who has been teaching from 2006. He's also a practitioner, an attorney at law with Rome Bar, admitted also before the Supreme Court. And his main areas of interest and practice are company law, bankruptcy, insurance, and aviation law. He teaches European business law, the focus of our center, our faculty, and today podcast at his alma mater, Luis Guido Carli. But he has been a researcher and a visiting professor at prestigious universities such as Yale in US, Heidelberg in Germany, Salamanca in Spain, Moscow State University in Russia, St. Gallen in Switzerland, Frankfurt in Germany, or Warsaw in Poland. He's an author of an impressive number of scholarly works, books, articles, case law commentaries. The best-known book, European Company Law, Text, Cases and Materials, is one of the most widely used texts in teaching European company law. And I have to mention is one of our main books in the reference list we have at Faculty of Law. Thank you, Nicola, for accepting our invitation to be the special guest at this new edition of Business Law Talks. As a start, I would ask you, because you are renowned specialist in European company law, what guided you as a practitioner, but also as a professor, to choose or to specialize in the area of European company law, and in the end to produce one of the best works in the field? And how do you see this teach at faculties of law? And because we're at the Bucharest University of Economic Studies, to future business professionals?
Thank you very much, Ovidiu, for your introduction and for the invitation. It is my second time here in Bucharest, and I love it. And you asked me about European business law. I came up with mainly the idea of concentrating on European business law and European company law in particular. That's because we have these subject matter taught at Luis Guido Carli for several years. We have decided that it was very important to have the background of several legislations concerning company law in particular, and other subject matters such as banking law, insurance law, financial markets, which mostly depend on the choices that are made at European level. And as soon as Luis decided that this course should be taught in English, and they honored me by letting me teach this course, I then started to take notes on the cases, on whatever is relevant for building up a system of European company law and European business law. And then I made a trip. I tell you this experience. I made a trip in the UK, and I was going around London, and I ended up near Cambridge. And the idea came to me to propose Cambridge University Press to print such a book. So I spent a night not sleeping, and then in the morning I sent an email to Cambridge University Press, and after a couple of weeks they accepted the project. So this is how the book was born.
Well, a great book, and as I said, one of the main instruments we're using in this field of European company law. And I suppose that also professionals are using this. Many companies, their lawyers, consider this as being one of the main tools in their activity. And now, because we are getting around European company law, I think those individuals, especially the companies, in time tried to access the internal market, to benefit from the rights granted by Article 49 of the Treaty on the Functioning of the European Union. And especially after the Court of Justice, the European Union started intervening and supplying us with interesting decisions, mostly due to the lack of harmonization. I think we're in a stage where we can comment a lot on how the institutions, the member states, and the individuals are seeing the development of the freedom of establishment within all this period. How do you see now freedom of establishment? How do you see the evolution of this, both through the secondary legislation which came, especially after the decisions of the Court of Justice, but also, and especially the latest ones, but also the decisions of the court? And how do you present this to students versus professionals as an expert in the field?
Freedom of establishment for companies in Europe is a chance, is something to exploit. And I see that since the eastern countries of Europe have joined the European Union, the process of benefiting from the freedom of establishment has developed tremendously. Everyone knows that there is a leader in Europe for SEs, which is the Czech Republic, founding thousands and thousands of these companies as a way to present a tool which would be very useful for foreign investments in their countries, should these foreign investors like to find a form which is at least known to the one that they use it, and which can use the English language. This is a very important point. I come from Italy. Italian is a more or less known language. But if you want to make business in Italy and you want to set up a company, you have to know Italian. You cannot do it in English. If you set up an SE, you would use English. That is a tremendous help for enhancing business relations. And for the other question that you make, what was the influence of the European Court of Justice in the process of approximation for the legislation of member states in the field of company law? I think a couple of decisions were tremendously influential. One of those has birthday this year, makes 25 years, is 25 years old, is Centrus. And with that decision, European Court of Justice affirmed the principle that there is an regulatory arbitrage at work in Europe, and it depends on the treaty. It does not depend on agreements among states and between states. And this has really changed the view of the European legislature towards company law. Allow me to say that after Centrus, all the European legislature have allowed €1 or 1 cent company. Is this good or not? This was the tendency that Centrus has produced. And the second decision, which for me has crucial importance as Centrus, is Polbot. After Polbot, as everyone knows, the European lawmaker, the Commission, has decided to pass the company law package, including in it encompassing new laws on cross-border merger, cross-border division, and mostly cross-border conversion, which was one crucial point to solve. Now we have a directive. Maybe this will help companies change the applicable company law they like.
You mentioned earlier Czech Republic with the so-called shell companies, and you're waiting for the SE, for the European company to develop and to be so active at European level. Still, only in some jurisdictions we have those more present, France, Germany, and some others. And those shell companies, most of them are not becoming active. We know that took a lot of time actually to get to an agreement of the member states, of the institutions, and then of the member states on having this form. Over there, the employee involvement had to be detached into the directive in order to be able to finalize the negotiations and have this European company. Still, as I said, is not maybe presenting itself, or at least is not actually chosen so much by bigger companies present at European level in some jurisdictions or in others. And I want to ask you if this is because of the economics, because of the business, or it's also because of how this regulation provides the way of setting up the SE functioning. If you consider this being too selective, too high as a threshold, should be actually diminished in time, should be, we should find other form next to this one. How do you see the SE present on the market? Because in the end, we need to adapt to a certain reality. Might be just business and that's it. We have it, we solved it in the past, or it's actually too luxurious for some companies to access?
This is a difficult point to answer, because member states do not see the tool SC in the same way. For example, I make a couple of examples. In Germany, we have important SCs. They are listed in the stock market: Allianz, Bertelsmann, BASF, Porsche. They're all SCs. But there are reasons which are rooted in the tradition of German corporate law, explaining why Germany has sometimes adopted SEs not as they are called UFO SEs, so just a shelf company, but as real company. And this is rooted, as you said before, in the tradition of involving workers in the process, in the decision-making process of the company. SEs in Germany are the only tool which permits to German entrepreneurs to abide a little bit, to make a distance from the strong involvement of workers that is mandatory for all companies having more than 1,000 or 2,000 workers, and is a tool also for adopting the monistic system instead of the dualistic. So it was a very good experiment for that environment, legal environment. They could choose what form of government could be considered best by the operators. We can consider also another example. For example, France. I have experienced recently a case which surfaced in Italy, and I have acknowledged that Vivendi, which is a big public utility in France, has also chosen the form of an SE, and there are no reasons in the legislation, in the French legislation, to adopt this form other than finding this form consistent with the needs of the shareholders, of the stakeholders, and so on. So even if the overall number of SEs is still, we could say, trivial, because 400 companies in Europe are nothing, considering the capitalization, how many companies are listed, how many companies do exist. I think the process is still developing and it's still appreciating this form of company. It should be at some point rethought and amended so that the SE model becomes the model for the big companies, for the listed companies, and then maybe think about the private limited company, which was unsuccessful. There are many attempts in the European Union to form the SUP or the private limited company as a European company, but they were not successful, maybe because it's too costly to shift to these forms.
And everything it's about shifting in a way where actually at a certain moment the reaction of the state was against the law shopping. Mm-hmm. And I would enter this area of businesses trying to get to the best place due to, I don't know, incorporation costs, due to managing complexity, due to other reasons. And we know very well lots of cases that in time brought us to even Paul Wood and the secondary legislation after it. And my question is, how do you see this evolution, and especially how do you see in the future, taking into consideration what you said, we have two types of management, which in some countries are more present, meaning in parallel, in others it's just one of them. We have also corporate governance rules now present and pressuring for the public companies to acknowledge those, but still going to one country to another in order to have more relaxed regimes on this. And if on these areas, even if now we past what happened with all the cases or the case law in this area, you see the possibility of still having conflicts and problems of transferring, of shifting from one jurisdiction to the other. We know very well that we have, after Paul Wood, solutions offered by the European institutions in shifting by having that directive implemented. But still there, we need the certificate, we need an approval nationally, we still have some national procedures, and we are in the years to come to see how actually this is going to work in the development of the business, and if it's going to be very easy for the companies to shift from one jurisdiction to another, if again this motivates the business itself. How do you see this shifting, like you said earlier, as an evolution in the future?
Well, you asked me to tackle the most bowling issue of European company law, and as I was talking about Centrus, everyone knows that Centrus has had a tremendous effect, a spontaneous effect on the legislation of many member states, because after the European Court of Justice confirmed that it was perfectly legitimate to set up a letterbox company in the UK to benefit from the regime of 1 cent company, all others member states had to face this situation. I cannot fight anymore with this phenomenon because the European Court of Justice does not allow to fight, and the other decision in Spirat confirmed that it's not possible to fight against this situation. Then just align myself, just do what the other do. This is called, in the American tradition, a race to the bottom. And this is the risk that Europe faces. All member states decided to allow €1 or 1 cent companies. And we face another situation which is similar to what happened after census. You recall me about the latest case that I have a little bit analyzed because it's an Italian case, so it's more close to my studies. It's Edelwerk. In Edelwerk, the court has confirmed another important piece of the European company law made in courts, which is, yes, the treaty says that registered office, principal place of business, and central administration could be considered on the same footing as connecting factors for companies, therefore allowing member states to both adopt the incorporation theory or the real seat theory. But as we know, out of the development of the case law of the European Court of Justice, after proceeding, after other decision, the real seat theory has become to have a very, very small room to act. And in particular, this happened with Italy, which should be a country adopting the incorporation theory. Yes, we do have the incorporation theory for 90% of the cases, but for 10% of cases, we had real seat because this law on international private law says that if a company is completely resident in Italy, despite that it's been formed somewhere else, Italian laws will apply. So we will disregard the choice made by the shareholders of these regulatory arbitrage. And the European Court of Justice said, no, you can't do it. There is no possibility not to allow that shareholders choose more favorable legislation. And this is a good principle. I understand it because it's the consequence of the development of the European Court of Justice case law. But it leads also to another phenomenon of race to the bottom. For example, many Italian and not only Italian companies decided to settle, to reincorporate in the Netherlands, just because Netherlands allows multiple voting shares much more than any other European country. And this was your question. Is it a point for the European Union to just allow what happens as a phenomenon, a de facto phenomenon? People and companies choosing their country where they think that the legislation is more favorable, or set harmonized rules as was in the past, as was in the beginning. You can choose whatever country because legislation are harmonized. I'm a bit skeptical on the intentions of the European institution to harmonize these fields. But this is, I think, a request because we need to protect minorities, to protect creditors, to protect other institutions, other parties which are interested in the managing of the company. Not only ESG factors. If they are caring about ESG factors, they must care about the closest interest to a company, which are minorities, creditors, and other interested parties, such as labor.
So just to understand, you are promoting even more harmonization and in a way to, going towards maybe a codification, uniformization of company law, European company law. But still you have doubts on this area. Now, for choosing a law or other, some reasons in the case law that we know and we teach were from incorporation costs and different other rules related to that, other conditions. But as you said, the managing part and in the functioning of the company, even maybe some other aspects related to end activity of the company, like daily mail to go to more capital issues and others. And for some time, yes, the law shopping was related to legal capital, in some jurisdictions seen as an important institution, legal institution, in others like it was a case of UK, not paying that much attention, and UK actually had to implement in time just because they became members. But most of the time, the shifting is done because of some financial, but especially tax issues. You are trying to get to certain jurisdictions which are better placed. And we can see, and in Romania nowadays, we are discussing a lot this because we have a deficit, we have some economic issues different than the others. Europe, all states have in Europe after the pandemic and after the war, the start of the war. Romania, anyway, now is preparing because we have elections in 1 week. After that, preparing somehow for some difficult times, and we'll have pretty sure to take decisions on increasing taxation, which is also on companies, will be also on corporate tax, on VAT, on others. So for some reasons, or the main reason might be this for the law shopping. Still, do you consider that the others, legal capital, administration, all the others are still important issues for which the shareholders and of course the administration of the companies to choose one jurisdiction or other, next to the getting back to this, to the tax ones, which you understand why?
Mm-hmm. I want to answer in more words to the issues I have tackled before and that you have taken as a starting point for the other question. I am in favor of harmonization. I like it. I like the system. I think the system has proved to be very intelligent. We had no other experience. It was an invention of the European Union to have harmonization. But as anyone knows, there are other proposals which at least mimic a little bit what happened in the United States. So the preparation of a European Company Model Act could replace the technique of the harmonization by pushing member states to have convergence. And of course, those who propose this system instead of harmonization, approximation of laws, they do demonstrate that there are cases in which a good example helps others to follow the good example. But it's not for everything. There are fields in which the legislator must do the legislator and must set out the principles based on which companies may choose. I take an example of this year, which happened in the United States, which is becoming famous, a famous decision. Everyone knows that all companies go to Delaware because Delaware is management friendly. But when Tesla went to Delaware and Musk for the 2018 decided he would compensate himself with almost $60 billion reward, then one shareholder, Tornetta, who will become very famous in the world, sued the company, and Delaware courts decided in favor of Tornetta. And the result was that Musk, so angry with the decision, changed the state of incorporation in 3 months. It changed to Texas. But if we change the state in search of a lighter, simpler, more friendly legislation, does the legislation do what it has to do, which is fixing principles, not only rules, but also principles? This is my concern. This is why I think that maybe uniformation is too much. We have an example, a good example of light harmonization, the SE. The SE is an example of light uniformation, and it's a good example. But if you want to have more approximation without any constraints to companies, I think the European Union can go on this point. And the other point that you made, and which is relevant as corporate legislation, is corporate taxation. I think this point shall be seen in another way. Corporate taxation depends on the services that the state may give to companies and how much the company is relevant to the member state. It is very easy to change legislation just because of a lighter or a more favorable taxation on corporate issues. But I think it matters until a certain point, because the European Union has repeatedly confirmed that companies may not decide to settle just in one place, Ireland, for example, just because Ireland makes you agreements which are unbearable for others. The Amazon, the Google cases teach us that there is another part of European Union law which says a state cannot help some companies to develop their business there just because they're taking advantage. If you don't take advantage, and you should have taken advantage, you have to recover the state aid. This was the decision taken against Google. So I think the European Union fights also this forum shopping for taxation purposes. Of course, being a federation of states with so much independence of the state does not help, but this will come.
And because you mentioned two things, especially the one, your view on the future harmonization towards something more, and I understand the option, the opinion, and I may concur with it. Still, there's now times, and now going to the second with law shopping, anyway, the forum shopping for different reasons. At this moment, we can see politically some changes in Europe. We can see that compared to other moments in our history, we have a push for more sovereign rights or more sovereignty of the states, coming from some states, but also in our states we have this. Again, we have elections, and we can actually balance this now. We can see this now in our elections. How do you see this process, if this actually will influence in a way, meaning that it won't be an objective, like you mentioned, you harmonize, but uniformity might not be the best because you may destroy some of the positive that you can find in one state or another, traditionally being there. But on the other hand, if you have just the political will not to change or to be more national, not take into account the objective view, so become very subjective just because you oppose the phenomena. And politically, we have these struggles today. We can see that in Germany, we hardly got to a government due to problems of finding the right union to European, pro-European one. And I suppose in the future will be the same in some other states. If you consider that this political changes and these new waves will influence also company law, or will stay objective and will see if it goes in one way or the other, will share the view, the federalized view of the United States, or just go and have its own way. As wrapping up a bit the company law and trying to see in the future, but take into consideration that in the end we have institutions and we have states that are changing, and the political views are more and more going towards protecting the sovereign powers of the states in different matters, even company law. Even if company law is connected to business and should be strictly related to the internal market and the businesses.
Member states are different on this point of view. I have the experience, for example, of Italy. Italy has not decided whether it wants to be liberal or protective to companies, because in all occasions in which the national economy has been put at risk during the 2008-2009 crisis, for example, we have decided to remove the rule on the passivity in cases of takeovers. And then we have decided that companies should choose whether they want to be passive or active in cases of a takeover. And this is not a European principle. Europe has left member states to decide whether they want to have companies defending themselves, so protecting themselves if it's a kind of protection or not. Italy has began mimicking. Last year we have passed a new law called capital markets law, allowing multiple voting rights, as I was saying. And everyone says it's too late. The big industries have gone already, and they have found an environment which is comfortable for them. So I think some processes cannot be stopped. They are market processes. And of course, some states will defend their economy, defend the nationality of their companies, and they will do what they will be able to do because the market goes in a direction which is not easy to change in the actual state, in the present state of the European Union. But there is also another point of view to make. Some years ago, Alstom, a French company, and Siemens, a German company, attempted to merge to fight together against the Chinese big companies on railway transportation. And the European Commission said, no, you can't merge. You can't merge because if you merge, you destroy the competition within the internal markets. This is a point that the European institution has to make anew. What is nowadays the internal market when for some fields of competition, the only thing relevant is the world market? Would we think that we have to split into parts Airbus just because it's the only airline producer in Europe? No, of course, because Airbus is struggling against Boeing, which is the only other producer of airplanes. So I think we need both change of view. Member states must accept that sometimes they will lose companies and parts of the economic because they are not keeping up with the development of other countries. But sometimes also the European institution must think that Europe is a single market, is already become a single market, and must be treated as a single market towards the rest of the world.
Yeah, you mentioned something that I thought also lately in connection to the internal market, the creation of the functioning internal market. As we know, we had the objective in Single European Act to have it by the end of 92, and then we said should be a continuous one because we progress and all the time we have to adapt. But still we have the same principles in the idea of creating, shaping competition, even company law within our borders. And here should be in order to create a competitive one, we should have the best one here and the functioning one here. But now, not only because of the latest 20 years where the internationalization and the digitalization and clearly more and more states developing, like the Chinese companies, we have also Indian, we have also others coming. And clearly the Americans were there for all this from the power point of view, meaning being present in the international business. But this is actually a change of paradigm. And my question is in relation to the internal market and this change, and also in relation to company law evolution, if we actually should think, if in the near future we'll have a change of the treaty, another amendment of the treaty, a new treaty, if we should actually have a new objective over there and adapting to an internal, not just internal market, but an international one, that we should create a single market which is adaptable in the international business, and by that, of course, in company law, all these adjustments in relation to other economies. Because it seems lately that we just limit the access of Chinese companies and Indian companies to the market without entering into competition with them, because they don't present the right facts, or the true ones, because they don't adapt to the principles, the standards that you have in Europe. But at the same moment, the question is, if doing this, we don't actually become a shell, a market protected, but without being able to become competitive, and the companies inside with, however we enact the secondary legislation, national legislation in the field, not to be adapted to the international business. And the question is, if you can see a sufficient pressure in the future for this change, or this will be actually, we still have others to solve till this moment. As a final question related to the internal market, but connected to the future of our companies in the European companies.
Very difficult to answer, and as a legal scholar, I am not used to think about so wide projects and future. But of course, I have an idea on this, and I think we must think of the function of the European institution in this process, in this moment, in this development. I see that Europe is led by many ideas which are not so well connected. One is the Alstom-Siemens decision. We have to say, as you said, and I share it completely, I concur, that the time for the internal market is now ended, and we have to think about the single market in the world, in the international business, to promote European trade, to promote European industry, to promote European services in particular, where we are strong and we could be stronger in the world. And this I don't see, and I think we lack a political movement for this objective, which may not be left to the initiative of the European Commission in allowing or not permitting mergers, and this is a political decision that maybe the Council has to make. For another point of view, Europe has decided in many fields, in particular with the green economy, to make very, very important steps towards the future that Europe imagines. It's okay, it's good for Europe. This, however, is something disconnected with the needs of the market and what the market wants nowadays. I see there are perils in deciding to switch completely green and change the automotive market, where the automotive market is so important for European economics. I see many doubts on the implementation of the latest directive, the so-called CS-DDD directive, which puts very important burdens upon big companies without a clear view of the positive results it may end up with. And this would be very dangerous if Europe would decline because of its legislation instead of because of its time to give the path to other economies. I see the difference with the United States. You could approve it or not, but the United States is market-driven. It listens to the market and what the market demands and then regulates a little bit what is necessary. We try to drive the market, and sometimes in driving the market, the risk of not making the good choice is very high.
I have to concur with what you mentioned and say that we have a change of paradigm. And EU as a whole has to find the unity and acknowledge that it has to be more dynamic in adapting to the new reality. And yes, maybe overview the merger control regulation and see the merger that you mentioned not being one that has a big concentration in Europe, but being a powerful one in Europe, in the world. This might actually bring us in a situation that we do totally different that we did when we started the market, when we had to demonopolize the big companies that we had, especially in Germany, but also in other parts, just to create, to shape, and have better competition. Now, in order maybe to save the market, to be more competitive, we have actually to accept this. But for this, we need a change of paradigm. And as you said, we need this political will. At this moment, I don't see the unity in this. And that's why maybe even in company law, we have just interventions and not a change of view on having this, just like in sales law. Yeah, we have a lot of contracts, online contracts. We have a lot of online sales, but we failed in creating, shaping a private law and shaping a common sales act. So, yeah. There are questions to be answered, but they are more political. We don't go there, we're just cause. So we'll continue commenting on what happens with the national European case law, and of course the legislation that comes after or during. And I want to thank you for being present at this podcast, but also becoming a visiting professor at our young faculty of law here at the Bucharest University of Economic Studies. It's a great honor having you here, and I hope our students appreciate it and will appreciate your added value and your opinions, of course, on the matters that happened. Here we are allowed to go a bit in the future. At the class, we still analyze the past. Thank you, Nicola, and we hope to see you also in the future at future editions of
Thank you very much. It was a pleasure, and I very, very willingly will come next times.
Thank you.